All right, the first issue raised by Mr. Kadine was a request to dismiss the count 3 unlawful imprisonment, indicating an insufficiency of evidence as to the restriction of Fatima's movements, indicating that the evidence shows that Mr. Ali is her father and that he has the right to restrain her. So first of all, there's been a significant amount of evidence that has been introduced in this case. And interestingly enough, I have thought about this issue in the course of the trial, just as I've thought about the evidence and the facts in this case. I was specifically thinking about this issue when I was working on instructions. One of the jury instructions proposed by Mr. Kadine on Mr. Ali's behalf is the affirmative defense of that the force was lawful as it relates to the allegation of assault, as it defined in the instruction to discipline of a child. And that instruction, of course, applies or could apply to the assault charge, which is count 2. And that instruction says in part, you may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing any act that is likely to cause, that does cause bodily harm greater than transient pain. The reason I was thinking of this in conjunction with the unlawful imprisonment is because it says it's unreasonable to do one of these acts to correct or restrain a child. And the evidence that the state is relying on relates to an unlawful restraint from their opinion, which includes the argument that Ms. Stone made as it relates to strangling Fatima until she went unconscious. Clearly, parents do have the right to reasonably restrain their children. We ground our kids all the time. Can't leave the house and do all of those things, but certainly the evidence presented in this case is sufficient to go to a jury, and I don't find that parents have an unchecked ability to restrain their children, or that the law allows for that, and therefore I will deny the motion to dismiss the unlawful imprisonment charge. Certainly, Mr. Kadine has the ability to make all of those arguments, in fact, to the jury as it relates to their consideration of the case. As it relates for the request to dismiss the assault in the first degree, Ms. Stone has provided 2 cases. Mr. Kadine, did you have a chance to look at those?
Your Honor, I did have a chance to look at Osman, and I think Osman predated the amendment to the assault charge. I also believe that that case involved a lot more of it involved a ligature, a sock in the mouth, and other intentional acts that would seem to elevate it beyond a simple strangulation.
And I understand that Mr. Kadine just got it, but it may be helpful if he looks at paragraph 37, which makes that analysis in Osman separate and apart from 3 means in which they decided that that was not an appropriate argument or a lawful argument on behalf of, maybe persuasive is the better word, on behalf of defense. Paragraph 37, standing alone, which is at, I believe, star 19 in the copy that the state has. It's page 6 of 6, addresses that specifically in terms of the amendment, saying it plainly it doesn't matter by the plain language of the new statute which is the current one under which we operate. So those facts are irrelevant to the analysis. They, in this case, were yet another reason, but the statute standing alone is sufficient.
And again, Your Honor, I would just say that it's clear in Osman that the intent was entirely different. That involved someone who was putting a gag in the mouth, putting chains around somebody's throat, tightening it, loosening it, tightening it, loosening it over a period of time, which is clearly nothing like what was the intent in this case.
All right, thank you.
The only other thing, I apologize, Your Honor, I would note is that the court also in Osman at paragraph 11 specifically says it addressed the asphyxiation piece, and then also separately in terms of the sufficient evidence argument, specifically addressed that the presence of the petechial on the neck also permitted the jury to find that the strangulation was likely to produce at least great bodily harm. The evidence supported the verdict on count 1. So it addressed the strangulation separately and apart as well, and consistent with that.
All right, thank you. So I read both of the cases, and although I have been able to quickly find these cases, I am familiar with this body of law in general as it relates to the fact that strangulation does not have to solely be charged under the assault 2 statute, as I believe that both of these cases address clearly the evidence that has been presented at trial. The state has presented prima facie evidence of assault in the first degree related to the fact that the facts are that Mr. Ali had Fatima in a I'm going to use the term chokehold, but that his arm was wrapped around her neck, and that he was squeezing her neck to the point that she became unconscious. She had multiple injuries on her neck. She had the petechial. Dr. Gilbert testified at length regarding the injuries and the potential impact of what Fatima experienced, and therefore I find that clearly the law allows for it, and that there has been prima facie evidence presented by the state that allows assault in the first degree to be something that will go to the jury for their consideration. Have any other motions, Mr. Kadine?
No, Your Honor, thank you.
So I don't want to just bring the jury back, and if I'm going to have Mr. Leary indicate that he has something for my consideration.
Not today.
All right. Bring the jury back in, please. Please be seated. Mr. Kadine?
At this time, the defense of Mr. Ali will rest.
Thank you. Mr. Leary?
On behalf of Zara Ali, defense rests. Thank you.
Thank you. Members of the jury, the evidence is now closed. What is left is for you to be instructed on the law that applies to the case, and then hear closing arguments of the lawyers. I think that the average person believes that jury instructions, because I've been talking them from the very beginning when we did jury selection, I said at the conclusion of the case, I will instruct you on the law that applies, but not just magically come about, and they take work to put together at the conclusion of a trial. And jury instructions really aren't addressed by the court with the lawyers until the evidence is closed. I tell you all of that because tomorrow the lawyers and I will address the issues related to jury instructions. And then, of course, once we know what those instructions are going to be, they have to be put in a proper form, many copies have to be made and the like. So we are not having you come in tomorrow. Also, because although the jury instructions will be finalized at some point tomorrow, closing statements are not brief. You heard a lot of testimony, there are many exhibits, and the lawyers are going to take time, all the lawyers will take time to make their closing arguments to you. And we don't break that up between days. So I can have you come back at 1:30 tomorrow because that would not leave enough time for you to hear all the closing arguments. So what that means is that on Monday at 9 a.m., we will begin the closing arguments. Closing arguments will conclude by the end of the day on Monday. Then you will begin your deliberations. We're going to order lunch for you on Monday. And what it means for you also is that you'll hear a portion of the closing arguments. Then we're going to take a break and be able to have lunch, not our normal hour-and-a-half break. And then we'll resume the closing arguments. All right. So that means that you are going to have Thursday, Friday, Saturday, Sunday. You're going to have 4 days. And it continues to be so vitally important that you ensure that in those 4 days, I know you have all been very careful and vigilant, but that you continue to be careful and vigilant to ensure that you are not exposed to any outside information about this case or about the law that applies to this case. Thank you so very much for your time and attention. We will see you on Monday morning. Please be seated. All right. So I put together the draft instructions, and I misunderstood this morning, Mr. Kadine, when you provided those additional instructions, that they were additional supplemental instructions. And I realized that after I had printed the draft instructions. So what I did is I have them on a separate page. And so what I'm going to provide everyone, and which I'll place in the court file, everyone's going to get a green copy, and it says on the front, draft court's instructions to the jury. The instructions are in the general order in which I would anticipate giving whatever instructions we end up with. When there are two completely different instructions, I have, like, for example, number 22 and number 22A, when they're completely different. When there are just portions of the instruction that are different, I bolded it so that we could see where it seemed that it was different. And on a couple of the instructions, I referenced the WIPIC. With next to bolded language, I might have said who proposed the instruction. Usually that information is honestly for me, but all of the instructions that have been submitted by the parties are either actually copy and pasted in here, or the language you want is included in these draft instructions so that we can talk about where there are contested issues. So, have the lawyers come forward. Those are for the state. Mr. Kadine and Mr. Laird. And I did not know if it would be helpful for the interpreters to have the actions.
Oh, sure.
Okay. So I have one for each of you. I would indicate that I did not print a copy for Mr. Ali and Mrs. Ali. I did not know if that would be helpful. Mr. Leary, are you asking that I print a copy for Mrs. Ali?
Unless it's in Arabic, which I don't
No.
expect the court to do, so no, I don't need an extra copy.
Okay, I didn't think so. But I wanted to check.
Yep, I appreciate it.
Mr. Kadine?
No, Mr. Ali indicates he does not need one.
All right. Finally, I said that all of the instructions are contained in the big packet and then that one page. There is one exception to that, and I just could not print another document. So in the additional supplemental instructions that Mr. Kadine provided today, in addition to the 3 instructions that are on the one page, which I just used A, B, and C because I couldn't number them to fit in where they would go in the instructions. You also provided instruction related to, it's the lesser included instruction itself, and previously the lesser included instruction, which is in the packet, it's number 22. It references only the lesser crime of assault in the second degree. Mr. Kadine proposed an additional instruction today, the same instruction, but indicating the lesser crimes of assault in the second degree or assault in the third degree. I actually did copy and paste that instruction in my Word version, but it was after I printed what you have in front of you. So when we have our discussion tomorrow, I know that if I ultimately give the instruction as it relates to assault in the third degree, that I would use the lesser included instruction that references both in the second degree and assault in the third degree. And that if that was not given, then I would use a different lesser included instruction if I give a lesser included. All right. Also, you will receive the final instructions, presuming we get noon tomorrow. You will have them in the afternoon, and then I'll have to have the lawyers verify by Friday at noon if they agree that the instructions are consistent with what I had ruled tomorrow, so that we can put them into the final form. So you still will get another chance to review them after, obviously, those are emailed to you tomorrow afternoon. And so, because I'm giving you this copy now at 4:20, I'm hopeful that you will have reviewed all of them before we come back into session, so everyone's not reading each instruction as we go through. Ms. Stone, do you have any issues that you want to address before we recess today?
I can't think of anything from the state, Your Honor.
Thank you. Mr. Kadine?
No, Your Honor, thank you.
Mr. Leary?
No, Your Honor.
All right. So we will be in recess until 9 o'clock tomorrow morning. Thank you.
All rise, court's in recess.